Good morning, students. Today I am going to discuss, analyze one of the important topics which was in news in recent times, and this is a small topic, so we must be well aware of the current going status of the judges in this regard. Okay, so the topic of our discussion of our analysis today is: can an FIR be filed against a sitting judge? Can an FIR be filed against a sitting judge? Because till today there is no provision that an FIR can be filed against the sitting judge, and here sitting judge means a judge of a Supreme Court, higher judiciary, Supreme Court plus high courts. Okay, so the question is, can the police or any investigating agency file a first information report against the sitting high court of Supreme Court of judge or Supreme Court judge and even the Chief Justice of India? Okay, the question was asked by Justice Arun Misra in a constitutional based hearing. So this was the question raised by the justice itself. Okay, it was his contempt to claim that the FIR in medical college bribery case directly involved Chief Justice of India. The answer is found is in K. Veeraswamy case. So earlier a judgment in K. Veeraswamy case, the Supreme Court has provided the guidelines with regard to filing of FIR, that is first information report, as per section 154 of Criminal Procedure Code, CRPC. Okay, in K. Veeraswamy case. So what was the guidelines given by the Supreme Court in that case? Okay, so it was held in that case that no criminal case shall be registered under section 154 of Criminal Procedure Code or an FIR. No registration of FIR was allowed in the guidelines by the Supreme Court against a judge of High Court, Chief Justice of High Court, or a judge of Supreme Court unless the government first consult the Chief Justice of India. So it was held by the Supreme Court itself that there is no provision to file any information, any first information report or any FIR by police or any investigative agency of the country against judge of High Court, Chief Justice of High Court, judges of Supreme Court, unless the government first take or first consult the Chief Justice of India. Means consultation with Chief Justice of India is prerequisite before filing of any FIR. Okay, the justification in this regard which was given by the Supreme Court was that the Chief Justice of India's assent was imperative and he was the participatory functionary in appointment of judges. As we are well aware that the appointment of judges in High Court or in Supreme Court of India, even their transfer is done with a collegium which is headed by Chief Justice of India. So it was held by the Supreme Court in K. Veeraswamy case that Chief Justice of India in this regard is participatory functionary. So the consultation with Chief Justice of India is but necessary if the government wants to file an FIR against judges of High Court or Chief Justice of High Court or judges of Supreme Court. The Veeraswamy case which was dealing with Prevention of Corruption Act in Judiciary, but the majority judgment, the judgment in this case extended it to any criminal case. Means the fact of the case were particularly related with the corruption. There must be prevention of corruption in judiciary, but the judgment which was given by the Supreme Court extended the ambit of the case and held that if there is a provision for an FIR in any criminal case, then government must consult Chief Justice of India first before filing of FIR, as per section 154 of Criminal Procedure Code. Section 154 of Criminal Procedure Code talks about first information report. Okay, due regard must be given by the government to the opinion expressed by the Chief Justice of India. Means government must give due regard to opinion expressed by Chief Justice of India. And what do you mean by due regard? And we must be aware, if there was consultation with Chief Justice of India was necessary, then it was held that the advice given by the Chief Justice of India was authoritative, means was final. So due regard, I think the consultation again here means the final verdict is that of Chief Justice of India. Okay, if the Chief Justice is of opinion that it is not a fit case for proceeding under the Act, the case shall not be registered. So the ultimate authority for filing of first information report against judges of High Court, Chief Justice of High Court or judges of Supreme Court is the consultation, the advice which will be provided by Chief Justice of India itself, who is also a part of judiciary. So here it means the ultimate authority to decide whether a first information report can be filed against any judges or not is Chief Justice of India. Okay, the verdict held that if Chief Justice of India himself is the person against whom the allegation of criminal misconduct are received, the government shall consult any other judges or judges of Supreme Court. So, if there is an issue where the Chief Justice of India is itself in question, then government had to consult other judges of Supreme Court. If the Chief Justice of India allows the FIR to be registered, the government shall for the second time consult him on question of granting sanction for prosecution. Again, if the FIR is lost, then government must again consult Chief Justice of India for prosecution. Means one consultation is not necessary for prosecution of judges. There must be consideration twice. First, before filing of FIR, and second, for the grant of sanction for prosecution. Okay. The Veeraswamy judgment holds that it shall be necessary and appropriate that the question of sanction be guided by and in accordance with the advice of Chief Justice of India. The majority in the Constitution bench classified a judge as a public servant. Okay. Consultation with Chief Justice of India while registering a criminal case against a judge, whether the High Court or Supreme Court, has been made mandatory to protect the independence of judiciary. So in the name of protecting the independence of judiciary, what we are doing and what is the current status is that we are holding the judiciary as the ultimate authority. If even there is a case, if there is a, what I can say is a 100% sure case of criminal misconduct by any judges, even then the government agencies can't register an FIR. Okay. This was with regard to the higher judiciary, with regard to judges of High Court and Supreme Court. So what are the guidelines for judicial officers of subordinate judiciary? The Delhi Judicial Service Association versus the State of Gujarat judgment. So this is an important case. Okay. Supreme Court was the product of notorious treatment meted out to the Nadiad Chief Judicial Magistrate by a few Gujarat police officers. It had the country's legal and judicial body in a port. So these are just fact and stories comparing the two issued direction of procedure. Okay. Primarily, the court held that a judicial officer should be arrested for any offence under intimation to district judge or high court. So, intimation must be given to district judge or high court, then only you can arrest a judicial officer. The immediate arrest shall only be a technical or formal arrest. The immediate arrest should only be a technical or formal arrest, after which it should be immediately communicated to district and session judge of district concerned and chief justice of the high court. So, the immediate arrest, if I am a judicial officer, I commit a murder, my immediate arrest will only be a technical or formal arrest. And after that, the same will be conveyed to district and session court where I will be posted and the high court under which I will be working. Okay. So, students, you should remember that district judiciary works under the purview of the state high court. They are not under the command of a state government. Okay. The arrested judicial officer shall not be taken to a police station without the prior order of district judge, and no statement shall be recorded from him or her except in the presence of a counsel. Okay. So these are the protection which are provided to judiciary. He or she will not be handcuffed. Section 3 of Judges Protection of 1985 protects judges and former judges of Supreme Court and High Court from any civil or criminal proceeding for any act, things or word committed, done or spoken in course of their judicial duty or function. No court shall entertain such complaint. Section 77 of Indian Penal Code exempts judges from criminal proceeding for something said or done during judicial duty. However, the government can initiate criminal proceeding against a sitting or former judge of a superior court under subsection 2 of section 3 of Judges Protection in 1985 if it can produce material evidence to show that a judgment was passed after taking a bribe. Okay, so if the government can produce material evidence, substantial evidence that any judgment passed by a judge was done after taking bribe, then the government can initiate criminal proceeding. Okay, so after the discussion in this regard, we can finally assume that judiciary is the ultimate authority in country right now, because as it was said in the famous Rowlatt Act of 1990, no vakil, no dalil and no appeal. The same applies here, no vakil, no appeal and no dalil for Indian judiciary. Thank you.